afternoon. My name is Molly Zimmerman. I'm the Associate Director here at the New York State Science and Technology Law Center, which is at the Syracuse University College of Law Technology Commercialization Law Program. Today, I'm happy to present, as part of our spring webcast series, Christopher Bonner from Hiscock Barclay, who will be presenting on SEC considerations for small and new companies. Mr. Bonner is a business lawyer counseling clients on regulation, disclosure, and corporate governance matters at Hiscock Barclay. He helps clients solve their corporate legal problems, simple and complex. He is a graduate of Harvard Law School, 1980, and Williams College. Mr. Bonner advises clients on security regulations and board of directors matters. He has advised numerous clients in business acquisitions, starting from the corporate governance issues when deciding to buy or sell, and proceeding through the contract and negotiation stages to the closing. He's assisted numerous startup enterprises in forming the corporation or limited liability company, and in shaping shareholders' agreements or operating agreement among the founders of the enterprise. His clients also include private equity investors in such enterprises. He co-authors the annual update on business associations published by the Syracuse Law Review, which covers the latest developments in New York corporate partnership and limited liability company law. And we are very pleased to have him here today. I'm happy to introduce Mr. Christopher Bonner.
Thank you, Molly. I appreciate that. I want to talk about the SEC considerations that small and new companies deal with. Small and new companies are a major source of technology transfer, as well as job creation and development. And so I want to get into the securities law environment within which those entities live, so to speak. Let's see. Now, if you'll unfreeze my slides here. Thank you very much. As if we have a fish here, the fish's environment is, of course, in the ocean. And the fish doesn't necessarily think much about the environment it lives in. My experience with entrepreneurs is they think quite a lot about the securities law environment, perhaps too much, because it's really interesting. It's complicated, and it matters a lot. I will focus primarily on those parts of it that the technology transfer company has to deal with. The primary goals of the securities laws are the prevention of fraud. That is to say, what they intend to do is prevent investors from investing their money with someone who does not tell them the truth. And in capital raising, there are three primary techniques that the securities law uses. First, and this is the most obvious but not the most important, is the review of a securities offering by a regulatory agency. There is also a general prohibition against making a false statement and also against telling a half-truth. There's, last but not least, there's requiring the securities salespersons, the brokers, the finders, and so on, to be licensed by a securities regulatory agency. We start out with an important concept for the startup company. What is the security? Practically speaking, it will be any investment contract you sell to an outsider. It can be a share of stock, it can be a bond, it can be a convertible note, it can be a stock option. The term security is defined in the Federal Securities Act as meaning any of these or any other interest or instrument commonly known as a security. Now, one of the things that happened as soon as the securities laws were enacted is that people tried to structure around the need to be regulated under the securities laws. And what early on happened, because the courts still remembered the Great Depression, was that the courts imposed requirements based upon the substance of the transaction rather than its form. They focused much more on, is your transaction, is your deal something that the securities laws were meant to cover? So what they focused on in terms of defining a security was a three-part test, commonly known as the Howey test from the case that presented it. Is your deal, is the relationship between the investor and the company an investment contract? That is, has the investor put in money or anything else of value with an expectation of profit? That's the second element, from the efforts of others. Now, it used to be that you could depend upon the qualifier that the efforts of others would be entirely theirs and not yours, that you'd be entirely passive. There are some investment vehicles where the investor himself or herself has to put in some effort of their own. In that case, there's still a security. So that's why on my slide I put solely in parentheses. An important thing to remember here is that the courts almost always follow substance over form. So trying to create a structure of an investment that will avoid the definition of security will generally fail. This became immediately apparent 20 years ago when a number of promoters attempted to sell membership interests in an LLC, because an LLC was then the new investment vehicle of choice. And so they'd say, well, since any investor in an LLC can be a manager, why don't we declare every investor a manager? And then the investors are not expecting profits solely from the efforts of others, but they are also managers themselves. So don't they also participate in the management? And thus we do not have a security, and thus we do not have to comply with the securities laws. Well, the courts ended that fairly early by stating that as a practical matter, you can have legally the right to be a manager. But if practically speaking, you cannot be a manager because you don't know anything about the company, you're not present at the headquarters, you don't have enough percentage ownership to make a difference. In that case, what the investor has bought is a security subject to regulation. Practically speaking, for the startup, it should bear in mind that if the investment is passive, it's very likely that the investment is a security. The regulatory scheme for securities is comprehensive. Not only the federal government regulates it primarily through the Securities and Exchange Commission, but there is also concurrent state regulation as well. There are state securities regulators charged with enforcing securities laws in every state. Their jurisdiction with the federal government is concurrent. There's a little bit of federal preemption, which I will talk about because it will matter for us. But the thing to bear in mind for both registration and enforcement purposes is that for your offering, you will need to find how you are complying with securities laws in every state under state law where an investor resides, as well as how you will be complying with federal law. Also, the state securities regulators are quite vigilant about fraud, and if they find out that a particular offering involves fraud, they are eager to bring an action against it. Also, the securities laws are enforced by private rights of action. Not all securities laws entitle the investor to bring a lawsuit, but enough do. Now, the critical method by which the securities laws originally sought to control fraud was through the process of registration. At the federal level, Congress, when it enacted the Securities Act of 1933, which was the first of 6 federal statutes, placed a generic prohibition in Section 5 of that act that said unless a registration statement is in effect as to a security, it is unlawful to offer or sell it in interstate commerce. So that set up the formula used in securities law that you'll see frequently, which is that you have to register or find an exemption. Practically speaking, registration costs too much because this is registration with the Securities and Exchange Commission, where a registration statement must be filed with that commission, where voluminous information about the company must be disclosed. The registration statement must contain audited financial statements, and the registration statement will simply stay at the commission being commented on, and with the registrant, that is the company that wants to offer, continuing to provide answers to SEC comments by means of amendments until the SEC is satisfied. Then the registration statement is declared effective by the SEC. The entire process today, in 2015, costs millions of dollars in primarily accountants' fees, but also in the fees of lawyers and in the fees of the brokers who will be selling the securities to the market. Practically speaking, SEC registration is not available unless the offering is in the amount of $50 million or more. I'm going to be talking primarily about much smaller offerings than that. Now, something to bear in mind as we go along is that disclosure in the securities laws is the tail that wags the dog. Mostly, in terms of substance, is your company a good company to invest in? The securities laws are almost entirely silent. They are not supposed to deal with that. They are only supposed to deal with, have you told the investor everything that a hypothetical reasonable investor would want to know? But in so doing, in order to get to the point where the investor is told all of that information, the company has to ask itself some searching questions. And it is the answer to those questions that frequently will take a not very good investment and make it a good one. So in effect, disclosure turns what is a bad investment into a good one, or takes a bad investment which cannot be improved and makes it unmarketable, prevents it from being offered and sold at all. Now, for the exemptions from registration, which are terribly important, that's what we care about. Before I get into Regulation A, I will talk quite briefly about the so-called private placement exemption. Under Section 4A2 of the Securities Act, right from the very beginning, from 1933, Congress said that you did not have to register any sales transaction by the issuer not involving any public offering. The term public offering was not defined. It was intentionally not defined and left vague to prevent unscrupulous promoters from structuring around it. But nonetheless, that was the exemption that was used, say, when with the pizza shop, Joe and his sister decided to sell part interests to their mom and dad. Over time, the case law developed concerning what is an offering to the public. And it turned out people were looking for some magic number, some bright line distinction. Is an offering to 3 people automatically not a public offering such that we don't have to register or find an exemption? Or is an offering to 500 people automatically a public offering? No one ever provided a bright line. No legal authority, no court, no securities regulator concerning what the difference is between a public offering and a private placement. There's lots of case law. The principal case which addressed the issue, or the leading case, I should say, was the case of the Securities and Exchange Commission against the Ralston Purina Company from the 1950s, when Ralston Purina was offering stock options not only to its inside chief officers, but was also offering stock compensation to many of its employees. The Securities and Exchange Commission said, well, you really ought to register that because quite a few of the employees, because they're not insiders, are not in a position to know what they need to know about the company. And therefore, you should slow down, register your stock, and present a prospectus that complies with the securities laws to your employees when you're offering them the stock. Because of the Ralston Purina case and subsequent cases, the easiest way to think about when a private placement becomes a public offering is to think about at what point does your investor need the protection of the securities laws. It can be as few as 3 people if they are not sophisticated investors. It can be even 1 person. Or in a situation where you have many investors who are quite capable of fending for themselves, maybe more. To address the problem, though, that there wasn't any bright line, Congress authorized the SEC to come up with safe harbors, where Congress said, SEC, adopt some rules so that if a company offers in accordance with their rules, they know that they are safe from the registration requirement. And that is one of the major sources for the complexity of the securities law rules that startups deal with, because they look to fit within these safe harbors. The safe harbor that is attracting the most attention these days is Regulation A. And that is because the SEC just adopted rules that are going to be effective on June 19 that expand this regulation. This particular exemption had been mostly unused for a long time. Let me describe it, and then I'll describe why it went unused. originally exempted a issue of up to $5 million over a 12-month period. And on the face of it, it looked really good. One of the huge problems until quite recently with any offering was, how do you publicize it without having to go through the full public offering registration process with the SEC? Well, under Regulation A, first you could test the waters if you wanted to. You could go approach investors publicly and say, are you interested in an offering that looks like this? And then if the investors said that they were, you could then follow it up by a full prospectus telling them what you were offering and how they can pay for it. It was quite good because it offered the possibility of a public offering where the all-in cost to the issuer might be considerably less than an SEC registration statement. It might cost perhaps $50,000 to conduct a Regulation A offering. What was wrong with it was that it did not preempt state securities regulation, which was concurrent. This meant that in every state where you wanted to offer and sell your securities, you also had to comply with state law. And a state law might be relatively simple, as it is in New York State, or it could be much more difficult. In some states, the state securities regulation requires not only that you file your offering documents, but the state blue sky regulators, that's what they call the state securities regulators, would also make specific requirements about what goes into your offering document. So you have a beautiful prospectus that has been approved by the SEC, but it hasn't been approved by the state regulator in a particular state. Now you have to go back and adapt it for that state. And if that wasn't enough, in some states there was actually what they call merit regulation, where the state securities laws, unlike the federal laws, affirmatively say that if some aspects of your offering are too unfair to the investors, you cannot have that offering in that state. So what Congress did with the Jobs Act in 2012 was to tell the SEC to expand the regulation to cover up to $50 million, and also to allow some state preemption. Congress, with the Jobs Act, thought that crowdfunding is a really good idea and wanted to allow it. But at the same time, there were plenty of securities regulators who lobbied Congress hard, saying, don't give away the store here, include plenty of investor protections. Now, the amended Regulation A is sometimes referred to as Regulation A+. There's a question whether it really makes the grade, as I will describe as I go on. Those amendments become effective on June 19. Under Regulation A, as amended, what the offerer does is file a prospectus or offering circular or memorandum. It files a disclosure document with the Securities and Exchange Commission. That's reviewed by the SEC, and no sales can be made until the SEC affirmatively qualifies, takes action to say that the offering statement is acceptable. There are two tiers of offerings under the new Regulation A. Tier 1 is up to $20,000 in any 12 months. It is still subject to state blue sky review. For what it's worth, the Association of Securities Administrators in the United States and Canada. It has undertaken to say, we will try to review and comment on your Regulation A offering circular quickly, and we will try to coordinate it so that you only have to deal with one set of comments from the lead administrator. The Tier 1 offering does not need audited financial statements, which is important. If you're offering a lot less than $20 million, then the cost of having an auditor come in and audit your financial statements is significant. Incidentally, in New York, you don't have to worry about this, practically speaking. There is a filing requirement for your offering document in New York, but there are no substantive disclosure affirmative requirements for your offering document. Under Tier 2 of Regulation A, the issuer can offer up to $50 million in any 12 months. But the securities have to be listed on a national securities exchange, like the New York Stock Exchange or NASDAQ, or the purchasers have to be people who are qualified. Now, the qualification can either be an accredited investor or the purchaser doesn't buy any more than the greater of 10% of the purchaser's annual income or net worth. Now, here I can mention briefly for those who have not come across the concept of the accredited investor before, it's significant for these offering exemptions because offerings to accredited investors will be entitled to a number of streamlined requirements that matter a lot. An accredited investor is an individual who has $200,000 or more in net income per year, or has assets, not including house, of $1 million or more. It also means most institutions. The concept comes from Regulation D, another exemption, older than Regulation A, quite important, and I'll be talking about that some more. Now, under Regulation A, if you've selected Tier 2, the offering is exempt from state review, but you do have to offer audited financial statements. Now, before I get into Regulation D, I want to talk about a significant component of the whole structure of securities law regulation. That is broker-dealer regulation. One of the methods for preventing securities fraud had been to license every person who's in the securities sales industry and to insist that they comply with standards of professional conduct. Those standards include knowing your customer. Is the security that you're selling your customer a safe, reliable security for a customer who is looking essentially for retirement income? Or is your customer a person who is financially very well off and willing to take a significant risk on a startup venture? That's knowing your customer. In addition, the brokers had strict requirements concerning how they handled customer money. This is important because you can imagine what happens when a broker tries to sell a investment that doesn't really work out. And the broker has taken the customer's money but has not kept it segregated, that is, separate and safe from the broker's other obligations. The broker could well be tempted to use the money that it has from the customer to try to do something else with it. And once the broker starts going down that road, the broker may very well end up being insolvent and having taken lots of customers' money with it, with nothing to return to the customer. That's one of the reasons why the Congress told the SEC to make sure every broker or dealer is licensed and regulated. You can determine whether any individual you're working with or any company you're dealing with is licensed by going to www.finra.org and checking on broker check to determine whether that person is named in the FINRA broker check database. If they're not, then they're not registered. They're not licensed to sell a security. Now, who has to be licensed as a broker? Can you somehow avoid registration by saying you're not a broker, you're something else? Here, again, substance triumphs over form. A broker is defined as someone engaged in the business of effecting transactions in securities for the account of others. And there is concurrent state regulation for the broker-dealers. Happily, there's only one place, usually, that you need to keep your records because the state and federal securities regulators work together on this. A dealer is a person who is engaged in the business of buying and selling securities for that person's own account. Now, here, an interesting and important note is that when a company offers and sells its own securities, technically speaking, it is a dealer. However, under federal and state law, there is almost always an exemption for the so-called issuer dealer. That is the issuer that's selling its own securities. And in New York State, one of the methods of complying with New York State blue sky law is for the issuer itself to file an issuer dealer registration statement with the New York State Department of Law, which is called the Form M11. Now, to determine what constitutes a broker, the cases use multi-factor tests, and they don't even say uniformly what factors count the most. So this is another one of what the lawyers refer to as you kind of have to know it when you see it. The multi-factors include, is the individual you're thinking of an employee of the issuer? Basically, if you're working for the issuer itself, if you are a member of the startup group who is putting the company together, that suggests you're not a broker. Doesn't prove it, though. Are you receiving a commission rather than a salary? Most of the cases will concede that receiving a commission is alone enough to make a person a broker. Not necessarily. That's not uniformly the case. So have the situation somewhat similar to the unfortunate fellow Hornswogler Bill. Hornswogler Bill was laying bricks at a construction site one day when the sheriff shows up and asks, I've got some papers to serve on Hornswogler Bill. Where is he? And the other workers point them out, and Hornswogler Bill says, this is really unfair. I have been laying bricks all my life, and I'm not a bricklayer. But I cheat one customer, and I'm Hornswogler Bill. Well, the SEC took the same position about brokers. They used to say that you take one commission, you're a broker, you need to be registered. The courts didn't go that far. The courts insisted that you have to look at all of the other things you might be doing. Well, are you taking a commission for the sale of one share of stock for one company, or are you selling securities of another issuer or issuers? That kind of indicates that you're in the business. Do you participate in negotiations between the issuer and an investor? Are you there talking about what the price is and why the investor should buy? Do you provide advice or valuation as to the merit of an investment? Do you tell the investor that this is a good deal? Do you actively find investors? Is this someone you already know, or did you go find a list of people or go decide to check with a number of people who might be interested? So based upon all of these tests, the courts will say, well, maybe the person ought to be a broker or maybe not. The drawback, if the broker is not registered, but should have been, is significant. There's a famous recent company called Neogenics Oncology, which was a startup biomedical company, which had the misfortune of obtaining most of its capital through persons who were not registered as brokers, but who probably should have been. The difficulty is nobody knows how far the remedies of a disappointed investor go. If a disappointed investor purchased stock from a broker who should have been registered but wasn't, does the investor have the right of rescission? That is, can the investor automatically get his or her full purchase price back, plus a reasonable interest component for the time value of money? Probably the investor can, but there's hardly any case law on it. So Neogenics Oncology found itself in the position that almost all of its investors had a right to demand payment in full of all of their money back. And that was roughly $30 million. And since the company had done what it was supposed to be doing with the money, which was conducting research, which produced some assets which were hard to value, the company essentially had no cash and no marketable assets, and with this liability of $30 million. And the company dealt with the problem by filing for bankruptcy, selling off its assets, and continuing to do its biomedical research, which is good news for people who want the doctors and scientists to find a cure for cancer. It was a very bad news for the shareholders. So make sure you use a registered broker if you use a broker. Another reason why the startup should focus on using a registered salesperson, if it uses a salesperson at all, is that someone who is not really much in the business of being a broker-dealer, can they really pull it off? Being a successful securities salesperson takes a lot of time and a lot of knowledge, enough so that somebody who is in the business a lot can easily get registered and knows why it's beneficial to be so. Now, as I'm building up to how the ordinary startup complies, I want to talk about full disclosure. The standard for full disclosure comes from the SEC's Rule 10b-5, which has a long history of how it started out as a kind of an afterthought in the list of SEC rules and developed into one of the most important rules that there is. Rule 10b-5 provides that in the sale of a security, in any transaction where there is a jurisdictional nexus with the federal government, that is, in interstate commerce, affecting interstate commerce, using an instrumentality of interstate commerce. Right now, we are using an instrumentality of interstate commerce, that is, electronic communication. In any transaction where there is a federal interest, it is illegal to sell a security by means of an outright lie, an admission, an exaggeration, or a minimization. Now, to prove a 10b-5 violation requires the plaintiff to show some additional requirements, but practically speaking, for the startup, what it needs to know is that it needs to make full disclosure to its investors. Not only can it not tell a lie, but here, this is the really important thing. It has to disclose everything that the startup knows that a reasonable investor would want to know. Now, there's no comprehensive checklist where you know that if you can answer everything on the checklist, you have satisfied the requirement to disclose everything. There are some good starting points. One of them I've referred to in the slide. That's what used to be called the Form U7. Form U7 itself still applies in some cases involving some, inside a particular state offering. But for our purposes, the useful thing to know is that this is an instance where roughly 30 years ago, the state blue sky regulators operated with the SEC to attempt to come up with a comprehensive checklist. The reason it's not comprehensive is that at the end of the checklist it says, plus disclose everything else that's material. Material is defined in the securities laws as being whatever a reasonable investor would want to know when he or she is making a decision whether or not to buy. The easy cases for material omissions, you can see it's when your projections are completely unrealistic. It can be you haven't disclosed something that's in the background of your founding group. Not disclosing that the company still needs to obtain licenses in order to do business. For our purposes, because frequently the startup team does not have significant black marks in their past, the thing that you have to disclose is how are you planning to get from the garage to the factory? Or that is, how are you planning to get to the point where your investors are going to start seeing some money back? That's really hard. It's this kind of thing that has to be included in a business plan. And you have to think about anything that a skeptical, intelligent investor would ask you before putting money in. The kinds of questions, yes.
Excuse me.
I have a question.
Can you address whether disclosure of prior art would be something that would be a material omission in a technology-based company?
Yes. Would in the case of a patent, would you have to disclose the existence of prior art to make sure that you complied with Rule 10b-5? Now, that's a judgment call. One of the things that happens with full disclosure and materiality is that quite a few things are judgment calls. And with prior art, what the startup needs to do is to talk with patent counsel about the likelihood that the prior art will invalidate a core patent. It could be that the prior art's danger presented to the patent is insubstantial and so unlikely that it doesn't have to be disclosed. On the other hand, patent counsel may say, look, if this patent is challenged, there is a significant possibility that it will be invalidated. Now, normally how that's handled is not to disclose the actual prior art itself, but rather to disclose as a risk factor that there is prior art that may present a problem. Here, we enter into a world which is also difficult to deal with. When you're a startup, how much do you have to disclose, even though it arguably might be harmful to the company and a trade secret? That's difficult. There is no easy answer to that one. Some startups try to deal with the problem by asking investors to sign confidentiality agreements. Practically speaking, that will kill your offering. The usual way to deal with it is to draft around it along the lines of, I've got a secret. That is to say, you disclose that there is a risk factor, but you try to make the risk factor unspecific enough that you don't show a competitor how to attack the company. But bear in mind that the problem will be that a disappointed investor will seize on the failure to make full disclosure for purposes of a lawsuit. Now, as I'm going to describe in a little bit, it is not so much a vague, arguably incomplete disclosure that will create a violation, although it might. Generally, where the startup is weakest is in failing to have a disclosure document. There is a vigorous difference of opinion out there among practitioners, among the lawyers in this area, about whether a PPM, a private placement memorandum, a written disclosure document, that is really necessary. And that depends not only on who you ask, but when you ask them. That is because the exemption that most startups are relying on now, it's not Regulation A. Why did I tell you about Regulation A? Because it's the hot thing. But Regulation A, I don't think it has much of a use for the kinds of offerings that technology transfer startups are looking at. Rather, the exemption that's usually relied on comes in SEC's Regulation D in what they call a Rule 506 offering. That's because if the Rule 506 offering is limited exclusively to accredited investors, you do not have to use a specific SEC form for the private placement memorandum. That is, your written disclosure can be drafted free form rather than have to include the specific items that the SEC calls for. Also, Rule 506 is used primarily because if you use Rule 506, you do not have to comply with state securities laws regarding what form your offering document takes or the substance of your offering. The only thing that's required under a Rule 506 offering for state law purposes is that you have to file a notice of some kind with a fee in every state where an offeree resides. So under this Rule 506, you say, well, if we don't really need to have any form of disclosure document, you say, if there's no form, why doesn't the form simply be the empty set, 0? We won't present them anything at all. Why don't we do that? Well, say there are arguments for and against that. And this is something which is current. It is an argument that startups have to deal with these days. You're going to run into it. And the best summary of the state of the law and the reasons for and against, actually, I found at the SEC's website. And I've quoted one of their statements that they make for the benefit of investors. On the slide, this is something which they're saying, look, investors, this is what we are telling you. Often there is a document provided. The document is not required. Well, that's their view at the SEC. And that's about as good authority as I'm going to find anywhere about whether it's actually mandatory. But, they say, the absence of this document may be a red flag to consider before investing. And that's about as close as the SEC can come to saying, look, if your offering doesn't have an offering memorandum, don't deal with it. Now, what are the risks if you don't use one? Well, one of them is you might get sued for failure to disclose a negative material fact. The investor comes in and says, you failed to disclose a risk factor. Okay? That happens. More frequently, the risk is that the investor will say, you made a promise that was not fulfilled. And one that frequently appears is, you promised that there was going to be a good market for my stock that I bought from you within a short period of time, such as you promised to take the company public within a year. Of course, the offeror is saying, I made no such promise at all. Interestingly, if the issuer used a private placement memorandum, then the issuer can say, look, I told my buyers only to rely on what I put in this PPM. Don't listen to what the salesperson says. And under those circumstances, there's some case law, and the courts are very sympathetic to the issuer. In effect, they say, if the issuer affirmatively discloses in an offering package what the investor should see, we won't let the investor come in and say, well, the issuer made a bunch of other promises too. So that is the primary advantage of the private placement memorandum, that an investor lawsuit can sometimes be defeated at the pleading stage. Customary warning here, prior results in the courts do not guarantee that the courts will come out the same way in the future. Now I'll talk about crowdfunding. Crowdfunding, interestingly, will intersect with Rule 506. In the Jobs Act of 2012, Congress told the SEC to adopt three kinds of crowdfunding. A public offering to all investors through funding portals. Second, allow Rule 506 to be available to accredited investors only in a public offering. Allow Rule 506 to be used for public offerings. And then expand Regulation A to offerings up to $50 million. Now, I talked some about mini registrations through Regulation A of up to $50 million. I will skim over Title III crowdfunding, the crowdfunding to Main Street, to the mom and pop investors, because while that's talked about, it probably isn't going anywhere. The SEC adopted rules under it, which are only proposed. They haven't been officially authorized. So in one important sense, standard crowdfunding as a method of funding a company isn't fully available. There's a way in which it is, but first I'm going to talk about the way in which it isn't, because it's hot news. This was crowdfunding for up to $1 million total. There were lots of requirements for the issuer. One of them is that for offerings over $500,000, the offering had to include audited financial statements. As you'll see from the slides, there were requirements for the issuer to make important disclosures. And the SEC, as directed by Congress, put together a list, which I've shown on this slide, of important things that the issuer had to disclose. Importantly, the offering had to be made through a funding portal or funding platform. And this funding platform had to do several things. It could not pick out any one or more of the investments and say that they were any better or recommended or featured or otherwise specified or shown to be different from any other of the investments. So the funding platform couldn't promote one over any other. It's just you get a visitor, like you or me, would go to the funding platform and just see a bunch of offerings there. We would have the opportunity to click on any offering whose logo or sign appealed to us. The funding portal is required to do several things to make sure that the ordinary individual investor who's not accredited, the mom and pop investor, knows what they're doing, knows that they are investing in very risky securities, and the funding portal has to take some reasonable steps to make sure that that investor comes within some, let me go back to this slide, fairly narrow, small limits of how much that investor can invest. Now, interestingly to me, this particular requirement is something that actually can be met with current software. I know that banking institutions have a software that gives them some assurance that an applicant for credit is creditworthy. And the SEC was thinking of using that kind of software for a funding platform so that, if I or anybody else come to the funding platform and give them some personal identifying information, they can then determine, to some extent, how much money we have and whether we qualify as an investor. How am I doing for time?
It's 101.
101. Okay. This is about right. Thanks. One of the interesting requirements for the Jobs Act, Title III crowdfunding, was that the funding platform had to provide a chat room for each issuer. So for each issuer, investors got to go into the chat room and talk about the company and ask questions and get answers and talk with each other about the offering. Obviously, that's an awful lot of hassle for only $1 million. And that's one of the reasons why the rules were proposed by the SEC, but they are not effective, and nobody knows if and when they're going to become effective. It turns out that several states, at last count, a majority of the states, had adopted state-only platforms. That is to say, they'd said, look, we're going to use one of the exemptions in the Securities Act from registration. And this is an exemption for offerings sold only within our state. And SEC Rule 147 describes what the SEC thinks when they're interpreting 3A11 of what they think should be a safe harbor for an offering solely within one state. Now say by using this Rule 147 safe harbor, each state was saying, we will allow crowdfunding to be done in our state along the lines of what Title III of the Jobs Act allows at the federal level. And this is an interesting development. We'll see what comes of it. When the state is Michigan or Texas, the market within which the crowdfunding can be accomplished is deep enough that we know the money's there. Whether it will be successful or whether it will be too successful, whether there will be bad transactions that get funded, we have yet to see. So for Title III crowdfunding at the federal level, the question is it worth the hassle? Now, I want to talk about Regulation D now and Rule 506, because Rule 506 did have an amendment adopted by the SEC in accordance with the congressional requirement to have it available generally to accredited investors. Until the Jobs Act, Rule 506 offerings to accredited investors had to be private placements. That is to say, the contacts between the issuer and the people to whom it was offering the securities had to be done almost exclusively by word of mouth from one individual to another. Now, a offering under Rule 506 that is made to accredited investors can be made to the public. If you are offering to accredited investors only, in effect, you can post the offering on your website. So, in effect, crowdfunding is now available for accredited investors only. And it also turns out that it's available over funding platforms, because the SEC had independently decided that if a funding platform does not do the things that we need to regulate broker-dealers about, then the funding platform is not a broker-dealer. Now, the SEC had focused on what it cares about back when it was trying to decide what a mom-and-pop Title III Jobs Act crowdfunding portal would be allowed to do. But in the process, it said, well, it seems to us that if the portal does not recommend any particular security, and if the portal does not handle cash or stock, that's very important. The portal itself will not handle your cash. The portal itself will not handle your stock. Rather, you do that directly with the company itself. So as long as you do that, you don't handle the cash, you don't make a recommendation, you'll be exempt from having to register as a broker. So then a number of portals say, this is great. What we will do is we will take Rule 506 offerings, we'll post them on our portal. We have the software to make sure that our investors are accredited investors only. And we will operate a website where, if you qualify, you can just go surfing through our website to your heart's content, looking at all the offerings we have available. Now, there are dozens, if not hundreds, of such websites up and running now. They vary somewhat in quality. I've seen at least one of them whose quality is quite high, so that I'm fairly confident looking at it from the outside that they've complied with all the securities laws. And in fact, this is an option available, and today is the option most commonly used by a startup. The disclosure document that the startup needs is posted on that website. The investor goes to the website. It will see your offering literature. If the investor wants to invest, the investor will work directly with the offering company. And the platform itself is careful not to charge a commission. It charges a flat fee, usually. It may be a set amount per month for the right to post your document on their website. There is, however, a huge problem with this, as I see it. It's a practical problem, not a legal problem. It's the absence of recommendations. One can imagine a good site having dozens, if not hundreds, of various offerings posted on it. How is the investor going to choose? Well, this is the classical securities problem, where they say stocks are sold, they're not bought. That is to say, when the investor goes to market, the investor sees an enormous array of offerings being made, and the investor says, I don't know which one to pick, and goes to a broker and says to the broker, this is the kind of thing I want, what have you got? And it's in that sense the broker sells the stock. So for the startup, how are you going to differentiate your offering from every other offering? That's a huge problem, because Rule 10b-5 in full disclosure says you don't exaggerate, you don't tell lies. Now, does this mean that the bad offerings, because there are plenty of people who break the law and there's nobody checking out whether or not the startup offering is telling the truth or not, does this mean that the extravagant promises on the website are basically going to beat out all of the reasonable promises that are made on the website? Nobody knows yet. But the result could well be that the funding platforms become impractical just because an investor who goes to them can't really spend the time to go check something out. Of course, there's nothing to keep a registered broker-dealer from reviewing the websites. But whether that's what it will come to, that's where things are going, it's too soon to tell. And what I want to leave the startup with is the concept of how to comply. Two things. First, focus on the disclosure. Focus on taking a business plan, turning it into an answer, a book that tells the investors what they need to know about your company and how you are going to make money for them. That's the thing for the startup entrepreneur to focus on. The securities lawyer will tell you what you have to file and when to file it and where to file it, so that you end up complying with the laws, you find the right exemptions you're using, you determine whether state blue sky laws apply or not. The entrepreneur's focus is on telling the story, not so much on finding the exemption or working his or her way through the securities rules. Second big point, if you use a salesperson at all, use only a registered broker-dealer. Don't use any unregistered binders, consultants, or whatever else they may be calling themselves. The big reason not to use them is that likely they don't have much experience in the field. The other reason, of course, is that you could be setting yourself up for a bad fall, legally speaking. With a crowdfunding platform, check out whether they're operating in compliance with the securities laws. Many do. So I'm not going to start out by saying crowdfunding platforms are dangerous, because I know that a bad one can be, but I've seen good ones as well. That's the important part. That's the securities law environment for startups. Now I would like to take some questions.
Can you comment on some of the ways to tell if it's a good site? The ones that you mentioned that are good. Is there anything in particular people can look for?
Well, one thing to check out immediately, of course, this is essential, is does it require you to give adequate information so that they can independently verify that you are an accredited investor? Now, this can be something you'd be a little unsure about simply as an investor. Simply because if you're the investor, you might not want to give that information to somebody you don't know very well. But to be an accredited investor, you have to have a net worth as an individual of at least $1 million or annual income of at least $200,000. The rules are a hair more complicated than that, but as a rule of thumb, that's where you start. So it's not enough simply to answer yes to their questions, because anyone can say, are you an accredited investor? Please check this form. They'd have to do some more investigations than that. So that's one of the things you'd want to check for. Have they asked for the kind of information they need to be able to determine whether you are really accredited? That's one item I can start off with immediately. A second is they can focus on the location of you, where you are offering from, and investors in what states you are offering to, because they will be concerned to know whether or not you have an obligation to make a notice filing under state blue sky law.
I think that wraps it up. Okay, that wraps it up for today. Thank you very much for being here. This will be posted on the NYS STLC website within 2 weeks under websites. And thank you all for listening in today.